So modes of winding up. Modes of winding up is one, could be winding up by the court. Let me put it there. So a company may start the process, or the court may start that process. And number two, we may have what we call voluntary winding up. They may agree. We may have what we call voluntary winding up. We may have what we call voluntary winding up. And when it comes to voluntary winding up, we have two types. One is members voluntary winding up, where the members of the company or the owners decide to wind up. And then we also have what we call creditors voluntary winding up. Creditors voluntary winding up. We'll look at that. We'll look at that later. We'll have what we call voluntary and credit members and creditors voluntary winding up. And number three way is winding up subject to the supervision of the court. Winding up subject to the supervision of the court. Winding up subject to the supervision of the court. We have winding up subject to supervision of the court. Winding up subject to the supervision of the court. So we have those three main ways of winding up. And it is important that anytime a question is brought on winding up, then you should be able to discuss. You should be able to discuss all those three main methods. That is winding up by the court, voluntary winding up, and winding up subject to the supervision of the court. It is always important for you to be able to discuss those three methods, those three major methods, as when it comes to winding up of a company. We'll be looking at each and every one of them. We'll be looking at each and every one of them for us to be able to understand what they entail. So we start by winding up by the court. Winding up by the court. Keep not your question will be answered as we proceed. Winding up by the court. Winding up by the court. And this one is also called compulsory winding up. It is also called compulsory winding up. And this is found in section 219 of the Companies Act. Section 219 of the Companies Act. And we have said that winding up by the court may also be called what? Compulsory what? Winding up. And compulsory winding up may occur in the following circumstances. Compulsory winding up may occur in the following circumstances. And one, if the company has by special resolution resolved that it be wound up by the court. And therefore, that is the first instance or the first circumstances under which winding up by the court may happen. In short, the company can pass a special resolution and resolve that we want to be wound up by the court. Number two is where default is made in delivering the statutory report to the registrar and in holding the statutory meeting. Remember, we looked at these things that we need, every company, public company needs to file those statutory reports. And therefore, when they are not done, the court may intervene and make a winding up order, right? It may make a winding up order. Number three is where there is failure to commence business within a year of incorporation, yeah? Or where the business is suspended for a whole year by the company. Remember, within 1 year, you should have started operating your business. And if that doesn't happen, then the court can wind up that business. And if you again, you suspend your business for 1 year, if you suspend the business of the company for a period of 1 year, then again, that will be we may lead the court to wind you up or give a winding up order. Now, the other thing that we also need to notice or to look at when you hear is when there is a reduction in membership below the statutory minimum. When there is a reduction below the statutory minimum, remember we talked about the statutory minimums of a company. So when there is a reduction of members below the statutory minimum, again, and if you carry on the business, for example, for a public company, we talk about minimum of 7. Yeah, if company carries on business for more than 6 months while the membership is below 7, then every member who is aware of the fact is will severally be liable. You remember that, we covered that. And therefore, in this case, the court will simply declare that you wind up. And number 5, instance or circumstances when the company is unable to pay its debt. If a company is not able to pay its debt, and then it can be forced by the court to do what? It can be forced by the courts to wind up. It can be forced by the courts to wind up. And the other one is, let me see if you have another one. When we have, we also have one, another one, number 7 or 6. When it is just and equitable, when it is just and equitable to wind up, and the petition should be allowed only as a last resort or for compelling reason when other remedies are not efficient enough to protect the general interests of the company. And here in a case of Westbourne Galleries Limited versus AC 360 of 1973, it was observed that the petitioner who relies on the just equitable clause must come to the court with clean hands, right? And if the breakdown in the confidence between him and other parties to the dispute appears to have been due to his misconduct, he cannot insist on the company being wound up, right? And therefore, as you go to petition the court, then you must go to the court with clean hands. You should not be the one who made a mistake or who misconducted himself or herself, and therefore you run to court for protection when you know you made some mistakes. And you go to the court, you must go to the court with clean hands. You must go to the courts. We must go to the courts with clean hands. Now, concerning this last circumstance of just and equitable, what is a just and equitable cause? What would constitute a just and equitable cause? What would constitute a just and equitable cause? Now, the court may order winding up under the just and equitable clause in the following few circumstances. One is when the substratum is said to have disappeared. Let me put this here so that we are able to follow. When the substratum is changing my, I want to post to the whole group. I hope we've been able to get that. I hope we have been able to get that. People are still joining at this time. So when the substratum is said to have disappeared, and this occurs when the object for which the company was formed has substantially failed, right? Or when it is impossible to carry out the business except at a loss. When that happens, then we say that the substratum has disappeared. Yeah, the substratum has disappeared. And when that happens, then the court can be wound up on just and equitable clause. Just and equitable clause. A substratum of a company disappears when the subject matter of the company is gone, or when the object of the company has substantially failed or become impracticable. And another one is when the existing and probable asset of the company are insufficient to meet its existing liability or liabilities. Again, it is important that I'm able to put this here so that you see or you are able to capture the circumstances under which we say that the substratum of a company can disappear. So it can disappear on those specific circumstances. So that is one of the reasons why, or one of the ways through which a court can wind up a company in a just and equitable clause. Number two way is when the management is carried out in such a way that the minority are disregarded or oppressed. Remember, we are looking at what is just and equitable cause, right? And we have said that one of the ways through which a company can be wound up by a court, right, is when it is just and equitable. When it is just and equitable. And we have said that for us to know whether it is just and equitable, then we need to look at the specific areas. And one of them is that the substratum must have disappeared. And we have looked at the instances when we can say substratum has disappeared. So number two of that is the one that we are looking at now, where we say that the management has carried out the business of the company in a way that the minority are disregarded completely or oppressed. When you are disregarded or oppressed, then remember we talked about the rights of the minorities. Yeah, we've talked about the rights of the minorities. And it is evident that you can petition the court. You can petition the court to wind up a company. You can petition the court to wind up a company. And the court will not make an order of winding up unless it is proved or proven that wrong has been done to the company by abuse of majority's voting power. And therefore, if, for example, you abuse the power of the majority by passing on resolutions that are not beneficial to the minority, and the minority feels aggrieved, and they can easily petition the court for winding up. Number three is where there is deadlock. Where is the deadlock? Where is this deadlock in management of the company? In case where two competing sides are not able to agree, or they have equal powers and they are unable to make decisions, then any group can petition the court there to initiate winding up of a company because of that reason. The reason is substratum, or the reason is for just and equitable cause and clause of the company. And number four is when the company was formed to carry out fraud or other illegal businesses, and therefore that can lead the company being wound up by the court because of just and equitable clause. And number 5, in case of a company incorporated outside Kenya and carrying on business in Kenya, winding up proceedings have been commenced in respect to of incorporation. Therefore, if a company was formed in Uganda and it's operating in Kenya, if it is wound up in Uganda, then it means that even in Kenya, the same case will follow. And therefore, we'll say that that is under just and equitable clause. Just and equitable clause. Now we look at petitions for compulsory winding up. Petitions for compulsory winding up. And the application for the winding up of company by the court or through the court may be presented by 1, the company itself, and that is where a company in a general meeting resolved to wind up the company, or it may be presented by a creditor or creditors, and number 3, it may be presented by petitions of any contributory. And remember, we said contributory is any person who is liable to contribute to the asset of a company in the event of it being wound up. That's a contributory. And therefore, even the contributory can make what? Can make petition for the company to be wound up. The other one is by, the order can also be presented by the official receiver, or by the Attorney General, after receiving a report of inspectors of the company affairs. He had commissioned that the company be looked into, and he receives a report from the inspectors, then the Attorney General can petition the court to wind up a company. You can petition the court to wind up the company. You can easily petition the court to wind up the company. Who's still joining us at this time? Yeah, to meet them so that they learn with us. Irene Mito, you're logging in 2 times. Don't know why. You must log in twice. If you do, you are likely to hear a lot of echo on your side if you log in twice. Charity's iPhone, what is your name? Can you indicate the other name or I log you out? Charity's iPhone, indicate your other name. We log you out. We also have who? Accountant Joram. Can you change your name? Change your name. Otherwise, I will log you out. Sir Davis, kindly write your 2 names. I'll be forced to lock you out. Who else is here? Yeah, I think that is all. Now, once I lock you out, you cannot log in for this session. You should know that. Once I lock you out, then it means you cannot log in for this session. We proceed. Commencement of winding up is deemed to have started from the date a petition is presented, and therefore it is important for us to note that when a petition is presented for winding up, then the commencement of winding up by the court is deemed to have started on that date. And when the order is made for winding up, it relates back to the date of presentation of petition. It will relate back to the day of presentation of the petition. What are the powers of the court? What are the powers of the court? What are the powers of the court in as far as the winding up is concerned? Now, courts have jurisdiction to receive winding up petition. They have the jurisdiction to hear and to make determination. In short, they have powers to receive the winding up petition, to hear it, and to make determination. The interest of the applicant alone is not of predominant consideration here. Your interest as an applicant alone will not be the predominant consideration here. It is the interest of the shareholders of the company as a whole, yeah, that forms formidable consideration as to whether the application should be admitted on the allegation mentioned in the petition, right? And therefore, it is not about the individual. It's about you petitioning the court on behalf of the shareholders, right? And therefore, the court may delay the order to enable the company to sort out a few things, right? And one of the things that maybe there is the settle a list of contributories, right? Number two, order any person in possession of any property of the company to surrender it to the liquidator. Make last call on the shares. And also where the company business is running, the company has power to appoint a special manager to take care of the business until the court determines the way forward. And therefore, the court may delay the order because of special circumstances. It may delay the order because of those special circumstances. Then what is the procedure for winding up? What is the procedure for winding up by the courts? What is the procedure for winding up by the courts? Now, a petition of winding up order against a company may be presented to the High Court of Kenya and must be supported by an affidavit of the petitioner according to section 218. According to section 218, whenever you make a petition to the High Court for winding up of a company, then you must be able to support it by an affidavit that you written and signed and taken to commissioners of oath to commission it. Now, when determining the petition, the court may, according to section 222, according to section 222, in determining the case, the court may, one, dismiss it with or without cost, right? That means if it is dismissed without cost, then it means that none would be responsible for payment of any cost that is incurred. Number two, if it is dismissed with cost, then it means that you would be liable for your own cost. Number two, the court may also adjourn the hearing conditionally or unconditionally, which means that the court may adjourn the hearing and put a condition on it, that on this date, we expect you to come back. Yeah? Or we adjourn the hearing indefinitely until another matter is brought into the court concerning the same. Number three is to make an interim order, which means that the court can also make an interim order. For example, they can require the management of the company, they can require the management of the company to call the annual general meeting for them to make specific decisions, right? For them to be able to make specific decisions. Number four, the court may make an order for compulsory winding up of the company. the court may also make an order for winding up of the company. May make an order for winding up of the company. So those are the four decisions that the court can come up with. One, dismiss it with or without cost. Two, adjourn the hearing conditionally or unconditionally. Number three, make an interim order. Number four, make any other order for compulsory winding up of the company. What are the consequences? What are the consequences of winding up? What are the consequences of winding up? Now, the consequence of winding up, we say that they date back to the commencement of the winding up of the company, like we have already said. And the winding up order operates in favor of all the creditors and the contributories. A sieve made on the joint petition of the creditor and contributor. So whichever a party makes the petition, it will eventually work for the benefit of these two, creditors and contributories. In the case of compulsory winding up by the court, the winding up dates from the presentation of the petition and before data resolution was passed to winding up of the company voluntarily, in which case the commencement is the time of the resolution. And therefore, we are saying that if there is no resolution that had been made, then the date of the presentation of the winding up petition would be the first date, or will be the beginning of the winding up. But in case a resolution had been made, then the winding up is deemed to have started on the date that that resolution was made by the company, right? And any subsequent disposition of property or any other transfer of shares or any other alteration of status of members will become void, right? It will become void unless, of course, the court gives other orders, right? And therefore, you cannot purport to sell a property after the petition has been taken to the court. You cannot purport to sell a property after a resolution is passed at the general meeting to wind up the court. Anything that you do after that becomes void in law. It becomes void in law, and therefore it is important for us to note that. The powers of the directors are also terminated. Yeah, the company, the powers of the directors are also terminated, and company servants are ipso facto dismissed. They are ipso facto. We put this here. The company workers. The company workers, we say they are ipso facto dismissed. They are ipso facto dismissed. And ipso facto is a Latin word which means by the fact itself. By the fact itself, the workers and the servants of the company are dismissed. And therefore, it is important for us to note that. And the other thing, the other consequence of this is that the official receiver, that is of the court, or the one appointed by the court, becomes the principal liquidator. The official receiver appointed by the court becomes the official liquidator of the company. Becomes the official liquidator of the company. And therefore, those are some of the consequences that will some of the consequences that will come up in case of winding up by court order. In case of winding up by the court order. What will be the duties of the official receiver? Duties of the official receiver. Now, an official receiver is a provisional liquidator can call on the directors to furnish him with a statement of the company affairs, right? Because he's the one now who is in charge, and therefore he is eligible to calling the directors of the company to furnish him with the company statement of affairs, and that has to be made in accordance with the statutory form that he gives, right? And verified by an affidavit. They have to swear that, as far as we are concerned, this is the situation. Now, that statement must always show, one, particulars of assets, debts, and liabilities of the company. It must show the particulars of assets, any asset that is owned by the company, any debt that belongs to this company, any liability thereof must be shown in that report. Number two, we must have names, residence, and occupation of all the creditors, right? Names, residence, and occupation of all the creditors. Three, there must also be securities that are held by the creditors and the dates when they were given, and any other information that may be required. So any security that the company has given out to the creditors, probably when they are taking up a loan, must be indicated there, right? And they must also indicate the date that those properties were given, and any other information that would be relevant to the official liquidator, right? Must be indicated there. Must be indicated there. I think the other thing that is important here is to look at the powers of a liquidator. What power does the liquidator have? What powers does the liquidator hold in regard to the liquidation of the company? And of course, after winding up order is granted, or after the provisional liquidator is appointed, they are supposed to take into custody or under their own control all the property of the company and any other right of the company. They are supposed to take into control and into custody all the property of the company. They should take into control all the property of the company, and they may exercise power over this, of course, with the leave of the court, or with the guidance of the court. One, they may institute or defend suits and other legal proceedings. They may institute, which means they may sue, right? Or they may defend where they have been sued as a company in all matters, whether it is civil, criminal, or any other way. Number two, they have power to carry on the business of the company so far as necessary for the beneficial, for the benefit of for the beneficial winding up of the company, for the benefit of the creditors and the contributories. Number three, they have power to appoint advocates to assist them perform their duties. They have power to appoint advocates to assist them in their duties or perform their duties. Number four, they have power to pay any class of creditors in full. They have powers to pay any class of creditors in full. Number five, they have power to make any compromise with creditors or persons claiming to be creditors. They can make compromise. And the compromise may mean that you are demanding this money within 3 months. You can give us, we can pay 50%, for example, right now, or within 3 months. Then you allow us to pay the remaining amount within 1 year. You are allowed to negotiate for the company and make compromises, for that matter. Now, a liquidator may, without a sanction of the court, do the following. Liquidator may, without the sanction of the court, do the following, which means that there are those powers that needs guidance from the court, and there are those that it doesn't need any guidance from the court, right? And some of the powers that is given where it doesn't need any guidance from the court includes: one, selling the company's movable and immovable property. It doesn't have to go to the court to get directions or powers. Number two, do all acts and execute all documents in the company's seal. It means if it is communication, you can do it with the company seal. If it is disposal, you can do it. Number three is prove and receive dividends in the bankruptcy of any contributory. Number four is to draw, accept, and endorse bills in the name of the company. Is given power to deal with the bills. Number five is to borrow money, the security of the company's asset. He has that power. He has that power to borrow on company's asset. Number five is to take out his official name on his official name letters of administration to a deceased contributory. He is able to take up letters of administration to a deceased contributory. Of course, there are many other powers that they have and that the courts may delegate to the liquidator, right? Like fixing time within which debts and claims must be proven. If you know, he can be given power by the court to decide that, no, we are calling out for anybody who has a debt or whose this company owes some amount of money to have made a report to us by this date. Those are powers that can be sanctioned by the court, or that the courts can give the liquidator. And when he's given, then he can exercise them. He can exercise them. Under what circumstances then does the termination of liquidator's power effected? Under what circumstances? There are three major circumstances. One is when he resigns. Two, when he is removed. Of course, he may be removed through the court also. And three is when he is released. That is after he's finalized his work. So when he resigns, he ceases to be a liquidator and he is removed, or when he is released from the work. Sorry. When number two, this is number two of modes of winding up. We have looked, so far we have looked at one, and that is through the courts, right? I hope you're able to follow that. Winding up by the court, that is what we've been discussing, right? Number two method was of winding up the court was voluntary winding up. Voluntary winding up. And that is what I'm calling number two. It is what I want us to look at. Now, a voluntary winding up is winding up by members or creditors without the interference of the court. This is winding up by the members or the creditors voluntarily without interference by the court. And here the members and the creditors may however apply to the court for any direction if and when necessary. It doesn't mean that the court is the one that is winding up the company. It is still the members and the creditors, but what we are saying is that they still have the liberty of seeking the courts, for example, interpretation on specific clauses, right? And therefore they can apply to the court for directions, to be given directions if and when it is necessary. Now, a company may be wound up through the following through the following circumstances. It may be wound up on the following circumstances. One is when the period of the duration of the company have come to an end, or the event which the company is to be wound up has happened, right? Now, the company, when this happened, the company needs to have passed what we call a resolution at the annual general meeting, which may be ordinary, unless, of course, the article provides otherwise. Sometimes your work may be for a specific duration, right? For a specific duration. And once that duration comes to an end, then you wind up your operation. Number two, it may be because of a condition that has happened or an event that has happened and has forced you to wind up your operation. So that is one circumstances under which voluntary winding up may happen. Number two is if the company passes a resolution to wind up voluntarily. If a company passes a resolution to wind up voluntarily, and we have said that we have two types there. We have two types of winding up. One is when the members voluntarily passes a resolution to wind up, and number two is when the creditors passes a resolution to voluntarily wind up. Now, members may pass a resolution to wind up if a declaration of solvency of company is made, and the declaration shall be made by a majority of the directors at the meeting or the board of directors, and that they have made a full inquiry into the affairs of the company, and having done so, they are of the opinion that the company should be wound up, and therefore that decision must be ratified. It must be ratified in the general meeting, in the annual general meeting, right? It must be ratified in the annual general meeting. And therefore, I hope that is clear. And number two is where we have creditors voluntary winding up, and this arises when the company is insolvent, right? Insolvent means you're not able to pay your debts as and when you should. Yeah. And in this case, the company might call the meeting of the creditors, right? The same day that they have a general meeting or a day after. Of course, these meetings must be advertised so that when the creditors meet, they might decide, now because you people are not able to pay our debts, we demand liquidation so that we are able to pay ourselves from the assets that are there or are the assets that belongs to the company. I hope that is clear. And when that happens, in these two circumstances, then they need to appoint or nominate a liquidator for the purposes of winding up the company. Yeah, they need to nominate a liquidator. Remember, we are talking about the creditors and the directors or the company itself. Now, in some cases, we may find that the liquidator who has been nominated by the creditor is different from the liquidator nominated by the company or by the board of directors. If that happens, then the one who has been nominated by the creditor is the one who will take over as liquidator. Yeah. And when they take over, they must, within 14 days of the appointment, publish in a gazette a notification and deliver the same to the registrar of company. That is a notice for the appointment as liquidators of the company, right? They must be able to submit that within 14 days to the registrar of the companies and also publish it in the gazette that they have been nominated. I hope that is clear. Number three, method or mode number three of winding up. Method or mode number three of winding up. We said it is winding up subject to the supervision of the court. Winding up subject to the supervision of the court. I know here there is someone who was asking a question, and therefore, this is provided for under Section 304, Section 304 of the Companies Act. And the Section 304 of Companies Act provides that when a company has passed a resolution of winding up voluntarily, the courts may order the continuation of voluntary winding up subject to their supervision or any other condition. That even when this order now is passed, no, the people will still petition the court, and the court may intervene and say, no, we want, it is okay, we agree that the company should be wound up, but it should be under our supervision. We want to know what is happening every step of the way, right? And this petition to the court may be presented by any person entitled to petition for compulsory winding up. Any person who is entitled to petition the court may decide to petition the court so that the court is involved. And this happens especially where there are fears that, for example, some of the shareholders, may it be the minority or otherwise, may be victimized. If that happens, then they can apply to the court, irrespective of whether you are the ones who have decided to wind up. You may decide to wind up, but some of members may not be comfortable. So they apply to the court and tell the court, yes, we are winding up, yes, but we would want your intervention in these matters. Kindly intervene and supervise this winding up. Now, the power for the exercise of which such liquidation would require sanction may be exercised only with the sanction of the court. And therefore, anything that the liquidator would do, it must be sanctioned or approved by the court, because here the court is the supervisor, right? The court is the supervisor. Now, Section 302 also provides that the company assets must be used to pay all the costs, charges, and expenses properly incurred in winding up, including the liquidation itself. Therefore, the winding up charges and expenses will rank in priority to all other claims. They must be paid first before any other claim of the share of the creditors and the contributories are paid, right? Must be paid. Now, the following preferential payments are required to be made in priority to all other debts. And I see what is here. Yes, we look at the winding up. And again, what we are saying here is we are dealing with the preferential payments, because when it comes to winding up, it is important to be cognizant of the fact that there are many debts that may be at play when we are winding up a company, right? And those debts must be ranked. They must be ranked in a particular way so that we know who would be paid first, right? For example, if you had given the company a secured debt, yeah, which is secured on a property, then you should rank among the first people to be paid. But if you had given what we call a floating charge, you given a loan to the company, but you had no specific property, then you rank below there, because you can only be paid if all the people who had been given property as security have been paid. And I hope that is clear. I know you've done this before, especially in accounting. I'm not sure whether this level of accounting is done by all of you. I am not sure, but if you've not done so, probably you'll be doing it in the future. Probably you'll be doing it in the future. And therefore, the following preferential payments are required to be made in priority to all other debts, and such debts ranks pari passu. We call it pari passu. They rank, put this here. We say that they rank pari passu, meaning that they rank in equal footing. They rank in equal footing, or they are treated the same. They rank in equal footing. One is all the government and local government rates that are payable within 12 months before the date of winding up. Those must be paid. All the government rent of not more than 1 year in arrears must be paid. Wages and salaries for any clerk or servant of service rendered during 4 months preceding the relevant date of winding up must be paid, right? All amounts in respect to the compensation under the Workmen Compensation Act that have accrued before the relevant date must also be paid. Any proceed left that is left after this may be given to the shareholders, and if any portion remain unclaimed, it goes to the public trustee. It goes to the public trustee as what we call bona vacatia, or the owner's property. Let me put this here. These are Latin terms. Bona vacatia. Is a Latin term that means owner's property. And that is where the property resumes or goes back to the government. And basically that will happen in all cases where you die intestate. Is it intestate? Yes. If you die without giving a will, that property ends up with the government, right? In the same case here, that any amount that remains and that is unclaimed will eventually go to the government in form of bona vacatia to the public trustees. Bona vacatia to the public trustees. Now, I would wish to stop my presentation there. And we'll go back to the discussion or group forum. We go to the group forum and discuss a few things. Discuss a few things there, unless there is any question that needs to be answered. Any quick one that needs to be answered here. I hope who had asked? Somebody, is it Kipnach? Geoffrey, you had asked a question. I hope it is clear now. I hope it is clear now. Good people, are we together up to that point? Are we together up to that point? Thank you, Alex. Thank you, Alex. So we still have next week to meet. But most probably we'll be concluding. On what we've been covering as we await for the exams, right? As we await for the exams, it is important that you are able to quote a few cases when you are arguing out when you're making out your argument, when you're answering your question, especially the essay ones. It is always important because most likely they are going to be application questions. It's not direct question from the book. Therefore, the books may not help you, right? Book may not necessarily help you. Application questions are good. They tell me whether you've understood what you've been learning your level of understanding, right? And therefore, I want to stop this presentation, right? I want to stop